process, which is going to be about over the next 10 years. So it's going to take 10 years, 7 to 10 years, but in the meantime, she will be able to continue to renew her work permit, renew her deferred action, and stay here and be given permission to be here. So it is one of those things. If you've been the victim of a crime, a qualifying crime, then you can qualify for this type of relief. The qualifying crime is determined by whether the crime resulted in your physical or mental abuse. Now, to properly file a U visa, you have to make sure that you get the certification of law enforcement. Now, with the T visa, the certification is not required. Under the U visa, it is required. So that means that you do have to have your name on a police report. You would have to show that in some way or form you did cooperate with law enforcement, and cooperating with law enforcement could mean that you were on the on a police report. So keep that in mind. All right. All right. So now today, what I want to talk about is I want to talk about the stepchildren and step parents. So stepchildren, step parents, and how you can obtain a green card, being the step parent or the stepchild of a U.S. citizen or even a legal permanent resident. And then I'm going to answer some questions. All right. So under immigration law, the step parent or the step child of a citizen or a resident, they do qualify to get permission to get the permanent residence. However, there are very specific requirements to obtain this. You have to be able to show that you, say you're the stepchild, that your parents got married before, so the US citizen and your parent got married before you turned 18 years old. For if you're the step parent, you have to show that you got married to the adult child or the child's parent before that child turned 18. If you don't meet this requirement, it means that you don't qualify as a stepchild or step parent of a U.S. citizen or resident under immigration law. Now, keep in mind that there are some situations where you would be able to still get the green card. You'd still be able to get the green card if you are the child of a citizen or resident. However, you're not going to get that if you if you are over 21, and if you can't show that you meet the requirements of being a step parent or stepchild. So it's very important to understand the rules related to being the step parent or the stepchild under immigration law, and in order to qualify here, because it's different. Once you're married, usually in the real world, once you're married to, you're the child of someone who's married to somebody else, that somebody else is your step parent. Or if you're the child of someone who is, you're the child of someone who is married to, or if you are married to someone and they have that child is your stepchild, no matter the age of the child. However, under immigration law, you can only qualify for those benefits as the step parent or as a stepchild if you can show that this occurred before the child's 18th birthday. So that's going to be the key here. And let's see. I'm just trying to fix this. All right. And then also keep in mind that even if, say, you're being mistreated, so this is important to know, because you say you're being mistreated by a citizen and you're the stepchild of the citizen. If you're being mistreated and you're under the age of 21, then it means that you can qualify for relief through VAWA. If you're the step parent of a US citizen and that US citizen mistreated you, now they're 21 or older, you qualify as the step parent of a US citizen child who's age 21 or older. So step parents, stepchildren can qualify for VAWA. So you keep that in mind. If you were mistreated by a stepchild or if you were mistreated by a step parent, you can qualify for relief under VAWA. So not only can your stepchild or step parent petition for you, but you can, if you're being mistreated, you can petition for yourself under those circumstances as well. And get this, if you are say you're the step parent of a US citizen, and you divorce the parent, but the stepchild still wants to petition for you, they can still do that because you still have a relationship with the US citizen stepchild. So it is a very, very, it's one of those little known provisions. A lot of people don't know that as a step parent or stepchild, they can qualify for their green card or for benefits under VAWA as well. All right, so now what I'm going to do is I'm going to go ahead and I'm going to scroll through and answer some questions here. So go ahead, put your questions in the comments. Hi there. So hopefully on YouTube, I have stopped echoing, hopefully, because it was a problem before. But let's go ahead. I'm going to go through and answer some questions. All right, so Queen Sarah 242, make sure you go ahead, send me a DM and call back the office. So is it safe to travel to Miami with a military ID as a military spouse if I don't have papers yet? So now, in regards to the military ID, you do have to check with the airline to see if that is a valid form of identification to travel with, and if it can be used for travel even across the borders or outside of the military base. Is it safe to travel to Miami? I'm saying that Florida is not a safe place for immigrants right now. If you're undocumented, you do have to keep that in mind, and it depends on what you're coming to Florida to do. Are you coming to visit? Or are you coming to work? How did you enter the country? If you came into the country without permission, then it means that you could possibly face penalties if you're traveling by car into the country, and who knows, even by plane, and someone is assisting you to come travel. They could be charged with a felony as part of the anti-human smuggling law in Florida. So it just depends on the circumstances, and then it depends on whether the airlines TSA would accept your identification. All right, so I won the consultation. Oh, you're welcome. And I'm so happy. I'm so happy, and thanks so much for your support. I really appreciate it. All right, so go ahead, put more questions in the comments. I'm here to answer. I've been here for more than 10 years and I have a baby here already. How can I fix my status here? So a baby alone is not going to get you the status, unfortunately. You have to qualify in some way, and this is where it's very important to get the consultation. Go to the link in the profile, and then when you go to the link, you will see a button that says schedule your own consultation. Schedule your consultation there. In addition to the free consultations, I'm also handing out discounts next week. So starting next week, you will be able to get a discount on the consultations. But if you need to book it now, because my schedule is filling up, so if you need to book it now, go ahead, go to the button, click on the link that says schedule and confirm your own appointment. It's really easy. Follow through with the form, fill it out, and you'll be placed on my schedule. How do temporary work through stepchildren who is how do you temporarily work through stepchildren who is over 21? So, if your stepchild is over 21, you got married to your stepchild's parent before that child turned 18, they can petition for you. Now, if they mistreated you, subjected you to verbal, emotional mistreatment, extreme cruelty, you could apply for VAWA as well. Now, that stepchild has to be a US citizen, and that stepchild has to be 21 years or older. This is not personalized legal advice. So, this is where it's very, very, very important to schedule an appointment if this is sounding familiar to you and you're trying to figure out whether this applies to you and how to go about it. All right. Go ahead, put the questions in the comments. Okay, so if there's no mistreatment, then still you qualify if you got married to the parent of your stepchild before that child turned 18, they can petition for you. So it says here, where are you located? So we're located in Boca Raton, Florida. However, we represent clients in all 50 states and around the globe. For example, we just got our client approved in Kenya. So we're all over the globe here. So no matter where you are, we can help you. All right, so I don't see any more questions coming in, so I'm going to call it a day. Yes, I did. Can I petition for myself? So no, your child, who's your stepchild, as long as you qualify, has to petition for you. Is there any way to go around this? My stepdad married my mom when I was 20, but no. Um, I'm not seeing the rest of it. So stepchildren, under immigration law, you have to meet that definition. He raised me from I was 6, but then you got married, stepdad married mom. So under the definition under immigration law, you would have to be under 18 at the time. You'd have to be under 18 at the time. Let's see. All right, what makes a child a derivative under 245I? So if they were under the age of 21 and unmarried and they were on the application or should have been on the application, then you would be considered a derivative under the application. I came here on visitor visa and I overstayed already. I'm a nurse. Can I use this to fix my status? So no, unfortunately. So this is where it's very important to explore your options after, before, explore your options before you overstay. Because a lot of people have the they don't have the correct idea here. They don't understand exactly how this works. A lot of people think, I'll just go to the United States, I'll just overstay, and then I'll somehow get it fixed. That's not how it works. You have to make sure that you explore your options before you overstay. Because, for example, in this case, you're a nurse. So what that means is if you had found an employer before your overstay and that employer had submitted a petition for you, then you would have been able to, within maybe 1.5 to 2 years, gain permanent residence through that route. But unfortunately, when it gets to the point where you've overstayed, you are going to face, you're going to end up facing issues because the employer cannot petition for you after you overstay. And this is what I try to emphasize here, because a lot of people fall for scams this way, where employers, they need employees, they want employees to come work for them very quickly. So they give them the false promise of sponsorship. And when they do that, when they give them the false promise of sponsorship, they come here, they end up overstaying and find out that the employer could not, did not really intend to sponsor them. Yes, exactly. And this is one of the things I'm trying to do is trying to help you to understand. While my clients, many of my clients have overstayed, a vast majority of them were in a situation where they overstayed. Um, but overstaying is not going to get you the status. What gets my clients their status are the options that they have based on maybe their family relationships, maybe their experiences, what they've experienced here, what they've been through. That's what gets my clients the relief. It's not the overstaying. And so if you're in a situation, while it's not too late to find out your options after you've overstayed, because a vast majority of my clients are in a situation where they've overstayed and they have solutions. So you can still look for your options. But if you're in a position where you can choose, and you're trying to consider your options here, you're trying to determine whether you should stay here, whether you can stay here, then or whether you should go back home. You're at a crossroads here. This is where it's very, very important to make sure you get a legal consultation, because you're going to get valuable advice and about what's the best option moving forward. And I'm very clear with my clients. So I'm not there to pretty up anything. I'm there to figure out solutions for those who I can help, and then advise you, provide you legal advice about your options where you're trying to figure out what next. My I-130 has been approved. Can I file EAD first so I can work, and then later I file I-485? My US husband says he does not have finances to file my green card. So I'm so sorry that that's the case, but unfortunately, this is where it's really an investment. So your husband is saying he doesn't have the finances. However, this is very, very, very important. This is a priority here. You should make sure that you prioritize it. So, just like, and you have to look out for your basic necessities, of course, but you also have to, when it comes on to your status, you have to make sure that you put that at the top of your priorities. The reason being, it's sort of like an investment. You pay for it now, and it is costly. It is costly, but you pay for it now. You are paving the way for yourself to have a future where you will be able to work more money than even the cost of this application. You're gonna make up tenfold, a hundredfold, a thousandfold what you spent getting your status. So invest. And this is where it's important to educate your husband about the importance of you getting status, that he cannot be complacent. I don't know what your situation is, but if you got your status, it would even help your spouse, because you're not having to sit down in the house or be fearful or deprived of the jobs that you want because you are without status. And sometimes this even makes me question the motives of the spouse in this case, because while I don't know what your situation is, when I have clients who are in a situation where the spouse is finding excuses why they should not file, it's usually a control issue. They don't want to see you get your status, because if you get your status, you're going to empower yourself. I've heard about, I've heard from the accounts of my clients where the spouse says things like, if I get you your papers, you're going to leave me, right? So they become insecure, and so because of that, they use the immigration status against you, or against the immigrant spouse. And that is considered as extreme cruelty. At a minimum, they should not be doing that to you. So, it's an investment. Now, here, the question says, you've been approved for the I-130. Congrats. You need to file the EAD. But guess what? To file the EAD, you have to file the adjustment of status application. You can't file for the employment authorization, that's the work permit first, and then pay for the adjustment. It all goes together. What if mistreatment is coming from in-laws and husband does not defend spouse from their emotional and mental abuse? Does VAWA help those victims? So this is a more complex situation, and I would want to hear more. And I think this is where in the consultations I really do get into detail, because I don't want to say no here, but I need to understand what is the dynamic. Because is the spouse using your in-laws as a weapon to keep you down? Is your spouse working with your in-laws to make sure maybe the in-laws do this to you to get you to comply with all of them, including your husband? I need to understand. Or is your husband also being submissive to them? Or is your husband, does your husband have some kind of fear of your your in-laws. So I have to understand that before I can answer whether VAWA counts here. But here's another thing. Whenever I hear this, your in-laws are subjecting you to emotional and mental abuse, I look at whether you are being subjected to in the process of them subjecting you to emotional and mental abuse. What else are they making you do? So in situations, in sometimes in situations like this, I see this scenario. You're here, you come to live with the in-laws because you and your husband, maybe you want to save money, maybe you don't have a place to stay right now, so you come to stay with them, and then they start to treat you like the maid in the house. You have to clean, you have to cook, you have to take care of maybe the grandkids, if the not your kids but maybe their other grandkids. You have to maybe if they have a business, you have to work in their business, and maybe you're doing this for little and nothing, or you're doing this for little bit of money, or you're doing it for no money at all when you should be getting money for working for them. In a case like this, where you're facing this kind of situation, where you're forced into this situation, you're coerced into it because you're going to be thrown out into the street if you don't cooperate with them, that could possibly qualify you for T status. So I need to understand exactly what your situation is, and this is where it's very important to schedule an appointment. So I encourage you. It sounds like there may be relief here for you, but I need to understand what the situation is here. Can a green card holder adjust the status of his 11-year-old child without the child leaving the U.S.? So I'll tell you in this case, that child cannot overstay. So as a green card holder who has your 11-year-old child, that child cannot overstay. If they overstay, automatically disqualifies them from adjusting status. If say if the 11-year-old has a citizen parent who's mistreating them, subjecting them to extreme cruelty, like maybe willful neglect, then that could possibly be a VAWA, a path to permanent residence. But say you're the only parent with a green card, then in this case, oh, by the way, if the 11-year-old is being mistreated by a U.S. citizen or legal permanent resident parent, so say the other parent is a green card holder, they also qualify for VAWA. However, say you're the only parent here, and your 11-year-old is out of status, then unfortunately, that child wouldn't be able to adjust status. But while I do highly encourage you to get legal representation here, if your child entered with a visa, but they're under the age of 18, they don't accrue unlawful presence. Meaning, say they're 11, they stay till 12, they stay for over 6 months, they're not going to accrue unlawful presence. So they're not going to have a bar on them. So when you go ahead and if they do have to go to the interview outside of the country, as long as they're not inadmissible in any other way, they should not be subjecting them to any kind of bar, 3-year or 10-year bar. But as I said before, I don't know what your situation is. I'm not your attorney, and I cannot give personalized legal advice here. This is where you have to be very careful with this process to make sure that you're doing it right, that you're understanding the implications here before doing anything. So schedule an appointment. and we can talk. Go to in the description of the video on YouTube, Facebook, Twitch. You'll see the link to Linktree. Go schedule your own appointment now. Thanks so much for your support, Dream Queen of Hearts. I really appreciate it. Thank you. If you're filing a merit-based petition, should I add the child right away? So if you're applying through your US citizen, now your child, whether your child is going to be on the application or not, you should be including your children, listing them wherever they ask you for children, because that's another red flag. Is if they see that your children are not listed, they're going to think you're trying to hide the fact that you have children. So always make sure whether that, no, usually where you see that happening is where they get very suspicious is, say you have children for somebody else. Could be during the marriage, could be before the marriage. And maybe there's some shame about that. And or maybe you just intentionally forgot to put it there. They can run your background there. They can look at past documentation to see that you have children, and they can identify that those children were born during your marriage to whoever is petitioning for you, and that can lead the officer to accuse you of fraud or misrepresentation or marriage fraud. So yeah, whether your children are going to be on your application or not, please make sure you disclose your children on the application, because it can raise some questions here. And if you want to even petition for your children in the future. But this is where it's very, if you're worried about something, don't internalize it. Go ahead and get the guidance and legal advice you need to make things right. So if when in doubt, just get the guidance. Now, back to this. If you're filing a marriage-based petition, should you add the child right away? You have to be careful about this. If your citizen spouse is petitioning for you, that child is not going to be allowed to be included in the application. Your citizen spouse has to petition for the child separately as a stepchild. So it goes back to the stepchild relationship, where if you got married to the citizen before the child turned 18, that child qualifies as a stepchild of a US citizen for immigration purposes. So in that case, make sure you're filing separate petitions. Now, if your spouse is a green card holder and you have your child from the get-go, put your child on the application so your child can go through the green card process with you. I have a visa. My fiance, who is a green card holder, I came to visit. He didn't want me to leave, so we set a date for a wedding. He got sick. I'm so sorry. I'm so sorry that happened. And my condolences. So this is definitely one of those complex situations that you're going to need some guidance on. I'm so sorry this happened. My condolences. Focus on healing, focus on just getting back to a certain point where you can move forward, and then you can figure out your options on how to rectify the situation. But I'm so sorry this happened. So they want me to work under the table. So it sounds like here you need to get that guidance. So go ahead and you can go to the link in the profile in the description of this video on YouTube, and you'll see the link. Schedule the appointment, because it sounds like there may be some relief here for you, but I need to find out more before I can confirm that. All right, so let me go ahead. If they waive the interview for marriage-based green card, how long to expect the green card? So you can expect a few weeks. No, well, let me correct that. You can expect it in anywhere from about a month to months. If they approved it, you got an approval letter, then you can then wait. You expect it very soon. Good day. I'm adjusting status, just waiting approval for my green card. Can I travel? No, 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 no. Do not travel until you have your travel document. I'm glad you brought this up because this has happened to people where you're applying and you think, I still have my valid visa. Let me just go ahead and travel. You travel, and guess what? They either won't let you back into the country but either way, your adjustment of status is going to be denied if you travel and you did not have a travel document to travel while your adjustment of status process is going through. You have to stay in the United States for the entire process, or you will face the consequences, which would mean if you left without that travel document, they're going to deny it. So even if you make it back into the United States, Tesh, go ahead, call the office and they can help you with the ways to confirm your appointment. So if you even if you make it back into the country, back to the US after traveling, you go to that interview, you're going to get a very unpleasant surprise. That officer is going to break it to you. If they don't break it to you in a letter form, they're going to break it to you down for you at the interview that they're denying you. Look, your marriage looks good. Everything else looks good, but you traveled while you were applying for adjustment of status, so denied. And you have to start all over again. So be careful. Got 4-year extension, my green 4-year extension and my green card. Can I travel? When you get your green card, yes. So usually, no, I think you're going from the 2-year green card to the 10-year green card. While you're applying for that, you got a 4-year extension letter. You can do everything you have been doing as a permanent resident, but don't leave that 4-year extension letter at home. Make sure when you're traveling, especially when you're anywhere, but when you're traveling especially, you take that 4-year extension letter along with your expired green card to show that you continue to be a permanent resident. If you come on a visitor's visa and decide to stay, what option do you have to get the green card and work permit? Schedule an appointment. So important. Don't overstay until you know what the options are, because for some people, there are no options. So don't think that just by overstaying you can get something. Just sometimes overstaying, you find out there are no options. If filing for VAWA and got through, how long does it take for the child to get through? So you still have to go through, get approved for VAWA, get your green card, and then the child will be processed to come here and join you if they're outside of the United States. If you got approved for VAWA, your child is here, then you would apply for the deferred action for your child as well, and then you and your child can move forward to adjust status. How can I reach you? So call 561-405-4889 or go to the link in the profile page. You will see everything you need on that profile page. Okay, if I got approved, do I get Social Security? Yes. So yes, if you get approved, all being well, you're approved for T status, you get your Social Security number with your 4-year work permit. So the T status does come with the Social Security number. Is it still safe to travel domestic right now for an undocumented immigrant like me? So what I would say is right now, the risk is low. It's not zero, it's low. Just you have to be very wary about what's in your background to make sure that you're not, say, wanted by ICE or anything like that. But keep in mind that that can change, because I am starting to see a lot of volatility. Now we're on high alert because President Biden is now negotiating with the Republicans about implementing tough immigration um, policies to appease them in order to get funding for Ukraine. So he's saying he's willing to give some concessions, and concessions are that he will implement some tough policies. They're looking at asylum, expanded expedited removal, meaning instead of going 100 miles from the border, now they would do expand expedited removal to nationally, all across the country. So and then parole, where if some people that are coming in, they meet a background check, they can then be released into the United States while they figure out their options. So right now, the risk is low, but not zero. But keep an eye on it, because things might start to get very different. And keep in mind, if they expand expedited removal to nationally, it means that it's no longer going to be a border, because right now they enforce expedited removal within 100 miles of the border, so close to the border. What they're saying is, if they expand the expedited removal, they can enforce it anywhere in the country. So in that case, I could very well see where the risk would be very high that you could possibly be subjected to expedited removal traveling anywhere in the country. So that's a scary thought, but right now we're looking at that. And this is where I say evaluate your options now, because things can change. I'm hoping not. I'm hoping that things take the turn. We have a government that's elected that will support humane, fair immigration policies while securing the border, while looking out for national security, but also that they understand that there are immigrants here that are contributing to the United States, to communities, to the workforce, that do deserve to be treated humanely and to be given a fair shot at relief. So this is the hope. But in the meantime, what we're seeing is I'm seeing a lot of buzz about immigration policies going in another direction. And President Biden, who is now in office, who has been the one who has opened the door for better immigration policies, is now talking about giving in to appease the Republicans. My nieces I-130 were approved. They did interview in JA 6 weeks ago, and their case says refused. So I would have to understand why it was refused. There could be so many things that could have caused a refusal. And then sometimes refusal could mean that maybe they're still waiting on your medical, or waiting for some kind of additional piece of information. And so that's going to change once they get it. But I have to understand what's going on there. So is this going for who is coming into the USA or who is already there? So expedited removal usually applies to those who have arrived in the United States within the last 2 weeks. So if you've arrived within the most recent 2 weeks, you're within 100 miles of the border, then you could be subjected to expedited removal if you're apprehended. I have not gotten the details of what the changes will be, and I'm hoping that it does not move forward. But with an expanded expedited removal, they're saying they're going to move this nationally. Now, whether they're going to move this to people who have been, expedited removal means that you're a new arrival, and they're instead of putting you through the court process, giving you a chance to for a hearing, they're sending you right out the country. So I'm assuming that it will still cover those who are new arrivals who have come in within the most two recent 2 weeks, but we have to see what those details will be. My 3-year T visa mark 08 to 2025. Can I start my green card application, and how long? So there is an early adjustment of status process that allows you to apply early, but it is a process. So there's step one to the process, and then you can apply. We help our clients with it, so go ahead, give us a call, and we can talk about it. Can an ex-convicted felony be approved after signing for an I-134A? It's possible, but it depends on what they were convicted for. That may be something that prevents them from signing those papers as a sponsor for you. Okay, so I'm an E2 visa holder in the US. Am I eligible for a green card, or can I become so the green card and becoming a legal permanent resident are the same thing. Green card holder, legal permanent resident, same thing. Now, there's no direct path from E2, which is the E2 treaty investor visa. That's where you start a business here. You get a temporary visa as long as you're running the business, and as long as you qualify, you can renew the visa to continue to run your business here in the US. You can bring your spouse, you can bring your child who's under 21 and unmarried here. Now, the downside with the E2 is there's no direct path to a green card. So you can't say have the E2, you cannot have the E2 for say like 3 years and then say, okay, now you qualify for the green card. However, what happens is after you've gotten the E2, you may have the background, the education, your business may have grown exponentially to the point where you can then apply for a green card based on investment, or you can apply for the national interest waiver as someone who has done very well in business and who can show that you meet a goal of substantial merit and national importance. So it depends on the business, your background, and whether you can qualify to for those methods of getting the green card. But there is nothing that says because you're a green card holder that you're an E2 treaty investor holder that you can then jump straight over to the green card. All right. So thanks everyone for your questions and your patience as I was dealing with these technical issues. I'm looking forward to speaking with you tomorrow. Tomorrow is Friday, so we will be handing out 2 more consultations. Now, before you call, please wait for me to be on here. I will be here, and then when I come on, wait for the code and then call the number. And then at that point, they would be more than happy to, as long as you call Eleanor, or Eleanor answers, Jalen answers, those are the only 2 staff members who can be authorized to give this to you. If it's any other member of our call team, then it means that you likely were not the first 2, because this goes to the first 2. But there will be discounts given out throughout next week. So what you can do is, if you want to get the discount, go ahead, and I believe it's starting on Saturday. So starting Saturday, if you go to the link in the profile, go there, and you will then see where it will appear that you will get your discount if you enter a code. You'll enter the code and it will take off the discount for you so that you can schedule your appointment. So it's all in one place. So if you want to get familiar with that, go to the link in the profile, go to Linktree. You'll see at the top, that button is going to be right at the top, and you can schedule your own appointments. So my schedule is filling up. So just make sure that you treat this with priority. As I said before, your status here in the United States is priority. So you should be trying to make sure that along with your other priorities, you put it right up there, because what you do to secure your future here in the United States is going to set the pace for how you excel, and what you will be able to do with your life, how you'll be able to gain your resources to thrive in the United States. Thanks again, everyone, for your time, and I'll see you tomorrow, 12:30. We'll go ahead and I'll do that two free consultations, and then we'll jump into another topic. Have a good one. Bye-bye.